So our final 804 exception is something frequently referred to as forfeiture by wrongdoing. And the idea behind this is that if someone makes a statement and you know that they're going to make that statement again against you in court, and you take some kind of action to, shall we say, discourage them from making that statement, whether that's simply by bribing them or threatening them, or in an extreme case like the Jackson case, killing that person, then the statement that the person previously made, you can no longer say that's hearsay. You no longer have an objection to a hearsay statement coming in if the person who made that statement is unavailable because you encouraged them to be unavailable. You forced them to be unavailable. So in the Jackson case, we're looking at the application of this particular rule. You have to have done something to make the person unavailable for the purpose of making them unavailable. So if you don't know this person's going to testify against you and you kill the person because he insulted you, then that doesn't qualify under the rule, and you could still make your hearsay objection to bringing in one of the witnesses' statements. But in the Jackson case, we're looking at mixed motive. So in this case, Jackson was a drug dealer in Orange, Virginia, a little town where I grew up. And it was a coincidence that this happened to be from this particular town. And other kind of trivia point on this case, the judge in this case, J. Harvey Wilkinson, on the U.S. Court of Appeals for the Fourth Circuit. If you remember when Chief Justice Roberts was brought onto the court, J. Harvey Wilkinson was on the short list along with Roberts for that appointment, and he's the author of this opinion. He was a former UVA law professor and then went on the Fourth Circuit. So in this case, Judge Wilkinson is looking at the question of what do you do when there's a mixed motive? Because if you look at Rule 8046, there's an important mens rea clause in this rule. You had to have taken an action that makes the person unavailable, intending that result, intending that the person become unavailable. If you just intend that the person becomes dead, well, then you intend they become dead for reasons unrelated to this case, then the hearsay rule still applies to anything that witness has said. But in Jackson's case, Jackson was a drug dealer in Orange, and he had a beef with Green, the witness in this case, because Green had robbed one of his dealers. And so prior to knowing that Jackson was going to testify, that Green was going to testify against Jackson, Jackson orders Green to be killed. Unsuccessfully. Green lives. Green is arrested. Green goes to jail. Green says while he's in jail, look, I'm ratting everybody out. After that, Jackson does have Green killed. Now, Jackson has two motives. One is he wants retribution for Green's robbery of one of his dealers. But Jackson also may well want Green dead because Green has said he's going to testify against him. So you've got evidence of two competing motives. And the rule requires that the making the witness unavailable, in this case by killing him, be done for the purpose of making the person unavailable. What if he has two motives? What if there's evidence of two reasons for this? Well, Judge Wilkinson says we're following the rule of the majority of circuits. It doesn't matter that there's another reason. If he also wants this guy out of the picture so that he can't testify against him, then we don't care if there might be a supplemental reason. If he also is trying to get even for the theft of his salesman. So under Rule 8046, the majority interpretation, if so long as you are making a person unavailable, have made someone unavailable at trial by scaring them, by bribing them, by intimidating them, or by killing them, and your motive for doing so, or a motive for your doing so, was to prevent the person from offering the testimony at trial that the person has previously said something about, then you cannot object to the statement the person has previously said before being dead or becoming scared, you can't object to that statement coming in under hearsay because you're the reason the person now is not able to come and make the statement in court. So you have forfeited your right to make a hearsay objection to that statement.